of introducing Chris Coons. We went to law school together, and then it's been all downhill from there for both of us. Sorry, I'm Stuart Benjamin. I'm a professor at Duke Law School. So I haven't done anything. Chris is a U.S. Senator. So he sits on, as you know, he sits on Judiciary. He is the sponsor of the Strong Patents Act, which has an acronym that's really clever that I don't have in front of me. And you all know that this is, everything that we're talking about today is directly in Chris's wheelhouse. He is less teched up than other people in this room about patent issues, but I will note that he actually was a chemistry major in college and worked for W.L. Gore and Associates before his later move to the Senate. So among senators, he's unusual in having any background at all in the world of science and technology. And he's also a deeply nice guy. So without any further ado, Chris.
Thank you, Stuart. It is truly rare for me in my role as a senator to be introduced anywhere as a deeply nice guy. So I really appreciate that. And I appreciate your friendship and your hard work in organizing this conference and your willingness to engage in what I think is one of the most interesting and important issues facing us in the Congress. There's a lot going on in the Senate and the House, but to me, the decisions we make in terms of intellectual property and how they impact America's leading global role in protecting and encouraging and incentivizing innovation are absolutely central, and they have long, impactful, and compounding consequences for our country. So as we move towards a markup this week on a piece of legislation that will significantly affect the future of patent litigation, and as you have this conversation today about post-grant review procedures, we have to remember that neither those procedures nor the acts of Congress exist in a vacuum. In my view, patents are absolutely at the center of our global leadership and innovation. And that's not just because of 8 years spent in a materials-based science company. It's also growing up in Delaware, where a little mom and pop called DuPont was sort of the dominant player in my community, and later entrants like AstraZeneca were really central features in my community. So my whole life, I have known people who were PhD scientists and patent holders and inventors and innovators. I did have a BA in chemistry, but frankly, that didn't earn me much more than the kids' table at Thanksgiving in my family of patent holders and entrepreneurs. So I just want to initially set the framework. I think patents play a central role, this constitutionally protected property right, in leveling the playing field for all businesses. This is certainly well known to all of you. And we have to continue to make hard choices to protect that role, that exactly the inventor, exactly the entrepreneur who has a major disruptive contribution to their field can stand on the same stage with some of the world's leading, most powerful and best financed companies if they have a patent and if the patent litigation system remains robust and protects the rights of those who have earned patents for their groundbreaking inventions. We have to preserve the incentives, not just for the inventor, but also for the investor who we expect to take the risk to invent in that disruptive invention and innovation and help them scale it and help them test it and prove it and grow it out. And so for these reasons, I think our patent system has to be vigorously defended as the absolute bedrock of our economy and one of the critical ways in which we distinguish ourselves from other competing economies around the world. So I'm particularly concerned about and interested in the markup we're having this week. When I cast my vote for the American Invents Act back in 2011 as a newly minted senator from Delaware, I joined many of my colleagues in making a wide range of changes, significant changes. I actually, in some way, in my previous role at Gore, participated in that. I was part of the 21st Century Patent Coalition in the 20th century, and much more senior and seasoned patent attorneys than myself. I am not a patent attorney. I'm not claiming that. Participated in those discussions, but it took many, many years and many iterations to make the big and bold and broad changes of the AIA. And one area, as we all know, that it tried to address was a serious concern, a well-grounded concern about patent quality. And in particular, the creation of a whole new series of procedures in order to deal with patent quality. And I know we have a number of folks here who've been a part of the hard work at the PTO and many new PTAB judges who've worked to implement these new provisions under the AIA. And yet, where I think we are today, just a few years in, is a crossroads where there's a significant mismatch in legal standards that have led to confusion, uncertainty, delays in enforcement and patent rights, and steadily rising costs for both plaintiffs and defendants. The data is in flux, as you've discussed today, and as many have debated. But just over the nearly 3 years since September 2012, early returns suggest that what's happening is much bigger and in some ways different than was anticipated by many of us who sponsored and supported the bill. About 3,000 IPR petitions have been filed, a number that far exceeds what were the early expectations of PTO. And for those petitions considered by the end of this April, 75% have been granted trials. And of those trials, nearly 2/3, I think 63%, of decisions have rendered all patent claims invalid, and another 21% have held some claims invalid. So if my math is still sound, that means 16% have rendered all claims as patentable. These figures, I think, should give us real pause, both about the consequences for those patents and patent holders, and for the broader point that when we legislate on intellectual property rights, it can have significant and unintended consequences. And as we move towards the next phase in congressional action on patent rights, I am urging my colleagues to be mindful of unintended consequences and their compounding impact on our country and our role in the world. So it begs the question, what does it mean to grant an exclusive right to intellectual property? When granting a patent, as I said, we expect investors to line up to invest significant risk capital, to build factories, to prove out inventions, to ultimately, hopefully, hire workers and to expand into our communities. And it seems hard to imagine that we would expect anyone but the wildest optimist to invest when a patent only has a 16% chance of being held valid in a post-grant review proceeding. So my fear is that many investors, if this kill rate continues going forward, will lose trust in the strength of American patents, and we will lose a lot of the energy and the investment needed to scale up startups and to make disruptive technologies available not just in the United States, but globally. These are some of the concerns that motivated me to introduce the Strong Patent Act, and I appreciate your compliment to the witty acronym, which really is Dan's invention, not mine. Dan Bachner, by the way, is a staff counsel who has made most of this possible, and I really am grateful for his determined and professional work in this field and his interactions with many of you. And I'm gratified by a number of my colleagues on the Judiciary Committee and off committee who've joined me. I have bipartisan support from Senator Vitter and Senator Cotton, Senator Durbin, and Senator Hirono, and many others who are listening to the arguments I'm making and have not yet decided where they will come out ultimately. At the time the Strong Patents Act was introduced, I'd heard from a number of companies with really compelling developments, particularly in the pharmaceutical and biologic space, who were victims of silent extortion, where these patent holders were being threatened with IPR challenges and had to pay settlements in order to avoid a process that they felt was unfair, unpredictable, and unjust. Thanks to the much more public recent activities of Kyle Bass and his fund, some of my Senate colleagues, I think, now understand the stake here in these administrative proceedings, which I think is, particularly in the area of pharmaceuticals, nothing less than our leadership in the world. My colleagues are confronting, hopefully, the reality that our ability to solve complex technological issues, to invent new groundbreaking materials, and to cure diseases is at stake. And in my view, our strong patent system, which has encouraged inventors and researchers to toil for months or years to create products and cures and materials and devices that have saved and improved countless lives, will be put at risk if we significantly weaken our patent system through this. I just got a letter from 93 different patient advocacy organizations. It was led by the Epilepsy Foundation of America that voiced this, I think, significant and credible fear. The organizations cautioned about the impact of weakening faith in our patent system. And they told me they are concerned, and I quote, that the high rate of patent invalidation in post-grant proceedings will chill investment in new treatments for patients. I found this letter particularly meaningful because these are exactly the organizations that are often in to talk with me, concerned with the makers of branded drugs and devices, concerned about rising cost issues and access, and who often are at loggerheads with the companies that are presumed to be behind the moves to weaken IPR. So these debates continue, but both sides understand in this context the fundamental importance of a strong patent system to advancing the frontiers of medicine, to giving hope to those who are suffering diseases currently without any known cure or treatment. So in my view, both in medicine and in materials where I worked, and in software and in other fields, the decisions of the PTAB reverberate throughout our whole innovation ecosystem. So as a result, while the data is still coming in and we're just closing out the third year, I think the time's ripe for a discussion on the merits of what can be done to address substantive and procedural concerns in post-grant proceedings. I want to touch on two of those briefly, if I could. First, I think it is important that patents granted by the United States PTO enjoy a presumption of validity. I think we should require arguments of invalidity to clear a clear and convincing evidence hurdle. Revoking the validity of an existing patent doesn't just disrupt investments in the patented issue, but sends a ripple, as I've just described, through the whole innovation landscape, casting a shadow over all patents in all sectors. And I think we cannot forget that our respect for patent rights set us apart as a nation. In this important respect, it doesn't matter to me, and I think it shouldn't matter in the future, that a post-grant proceeding is held at the Patent and Trademark Office rather than in a very busy district court like, say, hypothetically, the District of Delaware. What matters is that when a startup with a new idea approaches a potential investor seeking seed money, that investor has a reasonable basis to believe that the patent already granted by the U.S. government through the PTO after the investment of significant time and energy and review will be upheld unless the evidence is clear and convincing that the original grant was in error. I think it's also important to remember in this discussion that among the patents most likely to be challenged are those that represent significant disruptions to existing industries. It is exactly those inventions that we as a nation should be most on guard to make sure have a reasonable chance of advancing, yet they are the most vulnerable when a mere preponderance of the evidence standard can render those patents invalid. Under the current framework, a patent that challenges the market position of some of the largest companies can be challenged many times. So if you challenge 10 market-dominant companies with a new category redefining invention, you can be challenged 10 different times in inter partes review. Only one loss, and the entire basis for investment in that new invention can be wiped out. Why would you invest in a groundbreaking invention that you know is going to be pounded into the ground over the ensuing series of challenges? Second, I think we can and should address the issue of limiting the abuse we are seeing through the manipulation of public markets while still giving a broad range of businesses the opportunity to challenge genuinely weak patents. I believe we can find this balance by changing to a reasonable standing requirement, limit the currently overbroad threat to patent valuation while still allowing for a wide range of challenges. For example, any company that's been accused of patent infringement should be allowed to challenge that patent, even if they've only received a demand letter. In addition, coalitions representing small businesses and other nonprofits should be able to challenge patents that have been the source of repeated abusive conduct, particularly patents commonly asserted against unsophisticated end users, which is what initially gave rise to this so-called patent troll move in the Congress just a few years ago. In my work on the Strong Patents Act, I've been grateful to receive support from not only large companies in R&D intensive sectors, pharmaceuticals, biotechnology, medical device companies, but also those where I think much of the groundwork of applied science happens, universities, the National Small Business Association, the United Inventors Association. I welcome input from all of you on these proposals, and I look forward to a vigorous debate. I am hopeful that the Senate Judiciary Committee, after this week's markup, will hold additional hearings so that the whole Senate Judiciary Committee can hear from the whole range of folks whose interests and concerns and often life work is at stake in this proposed series of changes to patent litigation. Throughout these debates, I hope we can all remember that what matters is whether an investor today will decide to take a risk on a small team of inventors with a terrific idea, an idea that could change the world or save lives, when absent patent protection that is predictable and strong, it would be simply crazy to do so. Protecting these smaller companies and individual inventors ultimately benefits all of us, even the larger companies, such as the one for which I worked, that often obtain many of their best new products through acquisition or licensing. Nowhere is this more apparent or important than in the field of biotechnology and advanced medicine, where university spin-offs are at the heart of a drug pipeline that often ends with a major new breakthrough. Of course, there's many other business models in our country, and there's business models that I've heard from repeatedly from small business owners and from large business players in retail and service sectors and the development of apps and in IT, where patents play a very different role and where the impact of IPR is quite different and where their concerns are quite different. I understand that. But as I've said earlier, my key concern as we move towards further litigation in the Congress is that we have a clear-eyed assessment of the likely, unintended, and costly consequences of overreach and of change that is too swift and too broad. So, rather than choose one business model over another, we must resolve to maintain a patent system that is strong, vibrant, and works for everyone, and by doing so, preserve our nation's most important method of spurring small business innovation. I don't think I overstate the case when I say that the world is literally watching, and we have to continue to lead. Doing nothing is not acceptable, but overreaching and overfixing a modest problem, I think, has the very unfortunate likelihood of serious unintended consequences that will reverberate through our patent system for years to come. Thank you for a chance to be with you today. I'm happy to take a few questions. I'd like to thank again Stuart Benjamin for the invitation.
All right. Wait, I have to bring in the mic. It's like C-SPAN.
Thank you very much, Senator. I couldn't agree more. Along the lines of predictability and fairness and strong patent system, do you or anybody on the panel have an opinion or any thoughts about the broadest reasonable interpretation standard and possibly fixing it?
I'm not sure you'll get a more concise answer out of me. I mean, I think that is one of the proposed changes that we need. Did any member of the panel wish to comment? No. Fine. Good.
Thank you for your comments so far and for both of those proposals. I'm wondering if you could comment on the on your thoughts on a carve-out for Orange Book and Purple Book listed patents that could possibly get rid of the problems plaguing these biotech companies you're talking about while preserving what's the benefits of the system for the other parties.
Can you describe, for those who don't, can you say what Orange Book patents are?
Sure. So all of the drugs, the life-saving technologies that we're talking about that end up getting approved by the FDA. So Orange Book listed patents are single molecule drugs, and Purple Book listed patents are biologics. Have to go through an approval process, which then highlights that those patents actually will be infringed by certain products, and that creates a whole nother set of legislative litigation called Hatch-Waxman and or biosimilars litigation. All of that has been proposed as sort of conflicting with AIA, so parties have proposed a carve-out for those specific types of patents, which would reduce the burdensome litigation for those sectors. So, and I know that carve-out has been at least discussed, if not proposed. So, could you comment on that?
First, the bill that's before the committee that's going to be discussed and marked up, I think has a whole series of negative and unintended, well, probably intended in some cases, negative consequences for patent litigation, not just for IPR, PGR. And one of the ways that the bill lead sponsors in the last Congress tried to resolve a lot of the, I think, valid criticism of H.R. 9 was a series of carve-outs, was to sort of walk around the table and say, well, we'll give you this carve-out, and 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 then see if there was still, a bill left to go. I call that Swiss cheese legislating. That's trying to have enough of a bill that it's still worth passing while giving specific carve-outs to whole sectors. I would prefer that carve-out to no carve-out that helps protect what I think is one of the most vital and negatively affected sectors potentially impacted by this bill. But it wouldn't resolve what I think are a whole series of other concerns about the broad litigation reforms, and it wouldn't resolve some of the concerns I raised today about how IPR is being misused. So I'm intending to offer a series of amendments that are carve-outs. I don't like carve-outs. That's not how I think we should be stepping back, having real hearings where we actually hear from the whole range of the affected industries and from inventors and universities and large and small. We had a great hearing on the Small Business Committee that actually did have a broad representation. We had only one hearing in this Congress on Senate Judiciary that was, as Senator Durbin memorably commented, a panel of those who are in favor of the bill and those who are really in favor of the bill. And there was not one dissenting or critical voice. That's not a hearing. That's a presentation, let's be nice. So I would support that carve-out, but I frankly don't like and would prefer not to be in the midst of debating and discussing this carve-out versus this carve-out for the reasons I just laid out.
I'm a little concerned about the unintended consequences that may arise out of a very strict standing requirement. I still remember before AIA and before MedImmune, for example, as a patent attorney. By the way, I'm Goldstein of Stern Kessler Goldstein.
I'm sorry?
I'm Goldstein of the law firm.
Ah, thank you.
So I'm a patent attorney.
You're pointing to
yeah,
this.
I'm pointing to my name over there.
I'm like thinking, what's he pointing at?
I still remember as a patent attorney running into patents that would be a problem for clients of mine, and yet having no standing whatsoever to challenge them. And so patent attorneys for a long, long time wanted to have a more relaxed way of challenging patents without having to wait to get that threatening letter or the cease and desist or the lawsuit. And the US, as compared to Europe, was one of the few jurisdictions where you couldn't challenge a patent unless you had DJ jurisdiction. And the Supreme Court eventually relaxed the standard a little bit. So I'm worried that if standing makes its way into IPRs, that we will be back 10, 15, 20 years, and we will have sort of regressed. So I'm wondering whether it is in your brief or definition to strictly define what you mean by standing, or you will say whatever the Supreme Court says about standing is the way standing will be defined. I hope.
I would think the Supreme Court gets to say what standing is and isn't, and only by specifically statutory legislating subsequent to a decision would I be able to make some change there. I take your point. I will disagree that if there is some standing requirement in IPR, we would be, as you put it, all the way back 10 or 15 years. There would still be post-grant proceedings. There would still be this expedited, not in district court proceeding. I'm advancing a number of proposals for both standing and standards of review that I think will change what is a current wild imbalance. I think it's just not possible that only 16% of the patents granted by PTO are valid. Of course, I know they're not reviewing every single patent. I can see the bubbles over several heads going, that's statistically incorrect. That's not the point we're making. But to have a review that is faster, that is in front of a specialized type of reviewer, is still an advance, even if there is a standing requirement. So, I think there is a significant improvement to our system as a whole if IPR works in what I believe was the way it was intended. I will take an eye towards how the standing provision is drafted to make sure we don't have unintended consequences there. I am optimistic, yet not certain of success on any of my amendments, given the configuration of the committee and the hearing and the markup tomorrow. But I do think some change to the current bill and the manager's amendment, which I don't know about you, but I'm still waiting for copies of, although the print reports are beginning to filter out. We'll see. I don't think significant changes are going to be made in IPR in the manager's amendment, and I do think looking at standing is one of the places where we should be trying to come to a consensus that improves outcomes. Sure.
Okay. I guess 3-4 years ago when we were looking at the American Invents Act, the discussion was, well, there's all these weak patents out there, the PTO's underfunded, they don't have time to do the job, and we need a mechanism to basically get these patents back before the patent office with their technical expertise to more or less apply the standards that a patent examiner applies, which is preponderance of the evidence. There's no presumption of validity because this is the onus on these accused infringers in a district court, and it's impossible to fight these weak patents. So we created the PTAB, and we provided this alternative to litigation, which has worked phenomenally well. And I guess critics would look at your bill and say, well, now we're leveling the playing field, so to speak, and creating or taking away a lot of the advantages of that alternative by resetting all of those standards to what essentially is used at the district court. So I think there's a significant number of innovators in this country as seeing the PTAB as a relief, and taking all of those standards away basically takes the PTAB away as the option that the American Invents Act created. And just to get back to one of the points you made, if you got this this ground-changing innovation, that should stay an innovation no matter how many times people take a crack at it. So, on the one hand, we still need this outlet to fight the weak patents, but I think by raising all the standards to what is used in the district court, we're setting things back to where we were before the American Invents Act. Just look for your thoughts on that.
You're making essentially the same point, so I'll give essentially the same answer and then see if I can give any distinguishably contributing comment in my response this time. Whether or not IPR is working phenomenally well kind of depends on your perspective. There are some genuinely junk patents that were the subject of troubling and frequent and some would say baseless litigation that have been knocked out at a faster and lower cost, through a faster and lower cost, and some would say more professional mechanism. That's great. That's a good outcome. That's what I think was imagined in the AIA. But to come back to the standards and some of the procedural requirements that you would also face in district court doesn't wipe out all of the advantages in terms of who you're before, how quickly you get there, what should be the cost and scope and timeline of discovery, and the ability of the patent holder and the patent challenger to exactly how the hearing in the case proceeds is still distinguishably distinct from the district court. And at the kinds of numbers we're looking at today, and with the kind of behavior Kyle Bass and others have engaged in, there is at least one really important sector of our economy that I think is at profound risk if IPR is allowed to continue on its current trajectory, unreformed in any way. So does it work incredibly well? Look, if I were in-house counsel for an IT company or an app company and I was facing tens of millions of dollars in litigation costs and this was a mechanism to shut that down, I'd be arguing for it, absolutely. But if I happen to have family members who had Alzheimer's, or a community that suffers from sickle cell, or be active globally in the work against HIV/AIDS, I'd be really, really worried that in order to reduce litigation costs and to increase, sort of throughput and timeline and so forth on patent quality, we were genuinely putting at risk the scale up, not just the invention, but the deployment to the world of life-saving medications. Because the issue, to your point about a category redefining invention, yes, if it's sound and solid, it should survive all 10 of those challenges, no matter how big the Goliaths are that are pounding on it. But what investor is going to hang in with that inventor through a withering gamut of challenges? That's really the concern I have. And I think the point is that we've all got very different perspectives depending on which industry sector we work in. If I'm from Silicon Valley and I'm an app inventor, I've got a whole different view of the role of patents than I do if I'm the inventor of Kevlar. And it has a very different role in the future and the scale and the cost and the deployment. I think we need a patent system that works for everybody. And we've had a patent system that has had some significant flaws and failings. I'll close with this, if I might, just indulge me in this one. When the guy from the DSCC pitched up at my house and asked me to run for the Senate completely unexpectedly, this was out of the blue for me. I was a county executive at the time. He talked for an hour. And then he said, well, what is it you're concerned about? What do you want to help fix? And I said, PTO fee diversion. And he looked at me with horror and said, don't ever tell a real person that. And I said, no, I'm in Delaware. This is actually a big issue for a lot of people in my community because we are worried about, poor quality patent reviews. And I don't have all the answers. I don't pretend to have all the answers. I'm looking for your advice and input on how we can reach a balance in what is a really difficult field. It never occurred to me that the punchline to the joke would be, I'm for PTO fee diversion ending right until I become an appropriator, and I suddenly understand why appropriators jealously guard their prerogative to control little agencies. I'm still for ending PTO fee diversion, by the way. You help translate the vitally important world of invention and innovation and the litigation and investment that it spawns to a community of legislators who frankly have very little insight or appreciation for the dynamics of the world you represent. Thank you for taking the time. Thank you, Stuart and others, for the conference. But please, don't think that you are dealing with legislators who are deeply grounded and really paying very close attention. We've got lots of other things going on, from the Highway Trust Fund running out of money to NSA surveillance programs. This is a really important area, and I urge your engagement in a thoughtful and balanced way that isn't just for the interests of today's client or today's concerns, but that helps us see the long-term picture and the broader consequences. Because in this room, we have some of the most talented and experienced leaders and administrators and facilitators and litigants on behalf of some of the greatest companies and inventors in our country. And we really need your voice in this debate. Thank you.